on the phone.
Sorry, who's on the phone?
Tanya Lawrence.
Oh, Tanya, excellent. All right. Okay, we'll start off. Thanks, James. Good morning, everyone. I declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the strengthening oversight of the National Intelligence Community Bill 2025. These are public proceedings, although the committee may agree to request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege, unless you are giving evidence from outside of Australia. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as contempt. I remind all present that as Chair, I will ensure proceedings are conducted in an orderly, respectful and courteous way. In accordance with the committee's resolutions of the 26th of August 2025, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. The hearing today is being conducted with members of the committee and witnesses appearing by video conference. Not all, but some. Members and witnesses participating remotely are reminded to mute your microphones when not speaking. On that note, I'm now happy to welcome representatives of the Attorney General's Department and the Department of Home Affairs, as well as the Australian Border Force and the Australian Federal Police to give evidence today. Now, I'll start off and ask that for the Hansard record, could you all please state your full name and the capacity in which you appear today, and we'll start with the Attorney General's Department.
Thank you. Sarah Samios, First Assistant Secretary, Integrity and Criminal Law Division, Attorney General's Department.
Luke Muffet, Assistant Secretary, National Security and Criminal Law Branch, Attorney General's Department.
James Robinson, First Assistant Secretary, Strategic Policy, Department of Home Affairs.
Michael Burke, First Assistant Secretary, Immigration, Compliance, Policy and Intelligence, Department of Home Affairs.
Nerida Byrne, Acting Assistant Commissioner, Customs Compliance and Enforcement, Australian Border Force.
Good morning, everyone. I'm Lisa Gale, Deputy Commissioner with the Australian Federal Police.
Good morning, Alison Wegg, Assistant Commissioner for our Intelligence and Covert Services, Australian Federal Police.
Thank you.
Thanks, everyone. Okay, so although the committee does not require you to give evidence under oath, I should advise you that this is a hearing, it's a legal proceeding in the Parliament, therefore has the same standard as proceedings of the respective houses. Giving false or misleading evidence is a serious matter, may be regarded as contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Also, due to the short time frame the committee is working within to complete its review, please try and answer all questions or provide information to the best of your ability in evidence today, as further written answers will have to be provided within 24 hours if you do take anything on notice. Now, I'd like to ask, did any of the witnesses have an opening statement that they wanted to make today?
Yes, Senator. Attorney General's Department and I think Home Affairs as well have short opening statements.
Okay, yeah, if it's short, that'd be great. Thank you so much.
Thanks. So on behalf of the Attorney General's Department, thank you. We welcome the opportunity to appear as part of the review of the strengthening oversight of the National Intelligence Community Bill. The bill has been reintroduced in substantially the same form as what was the Intelligence Services Legislation Amendment Bill that was introduced into Parliament in 2023 and previously considered by this committee. Conscious that there are new members of this committee, I wanted to briefly touch on the core purpose of the bill before moving on to the differences between the bill currently being considered and the former bill. The challenges of the national security environment have required increased collaboration and engagement with agencies across government. To counter security threats, Australia's 6 intelligence and security agencies are increasingly partnering with an additional 4 agencies: the Australian Criminal Intelligence Commission, the Australian Federal Police, the Australian Transaction Reports and Analysis Centre and the Department of Home Affairs. Collectively, these 10 agencies comprise the national intelligence community and each plays a vital role in protecting Australian citizens and Australian interests. This bill, like the Intelligence Services Legislation Amendment Bill before it, intends to strengthen and expand the oversight responsibilities of the Inspector General of Intelligence and Security and of this committee to ensure all agencies within the national intelligence community are subject to a holistic oversight framework. The bill would establish enhanced statutory and parliamentary oversight commensurate with the powers and responsibilities of agencies within the national intelligence community. The bill would achieve this by expanding the jurisdictions of the IGIS and this committee to the whole of the ACIC and the intelligence functions of the AFP, Austrac and Home Affairs, enabling this committee to review proposed reforms to counter terrorism and national security legislation and all such expiring legislation, and make technical amendments to the committee-related provisions in the Intelligence Services Act to modernise provisions and enhance the efficiency of the committee. Strengthening the relationship between oversight bodies, including by providing a mechanism for this committee to request the IGIS inquire into certain matters and the Insulam provide briefings to the committee, and amending the Criminal Code Act to provide defence officials with an exemption from civil and criminal liability for certain computer-related conduct. The changes to the bill, as reintroduced, would entirely remove the ACIC from the jurisdiction of the Parliamentary Joint Committee on Law Enforcement and bring it wholly within the oversight of this committee. Amend the Insulam Act to ensure the Insulam is able to conduct own motion reviews into the full suite of contemporary Commonwealth counter-terrorism and national security legislation, and to modernise and streamline reporting and administrative provisions in the Insulam Act, and to make technical and minor amendments to correct inconsistencies and reflect the passage of other legislation since the introduction of the former bill. There has also been a change in the proposed approach to defining the intelligence functions of Home Affairs in regulations to be made under the Inspector General of Intelligence and Security Act, from a structural approach under which Home Affairs intelligence functions would have been defined by reference to its intelligence division, whose functions have now been dispersed, to a functional description of the intelligence activities undertaken by Home Affairs. The bill was developed in consultation with the officers of the IGIS, Commonwealth Ombudsman and Insulam, and the National Intelligence Community. The departments of the Prime Minister and Cabinet, Home Affairs, Defence, Foreign Affairs and Trade, and Infrastructure, Transport, Regional Development, Communications, Sports and the Arts were also consulted on the bill. Thank you again for the opportunity to appear and for your consideration.
Thank you very much. Now, who else had it? Was it the Department of Home Affairs?
Yes, thank you, Senator. So just a short opening statement from us. Thanks to the committee for the opportunity to appear following the department's submission to the review. I note that our submission reflects the views of the broader Home Affairs portfolio, and I'm joined today by representatives from the Australian Federal Police and the Australian Border Force as well. Austrac, the ACIC and ASIO are not in attendance, but any questions relevant to their functions we'll be able to take on notice if required. In relation to the bill, we're very supportive of the expansion of the oversight over Home Affairs' functions. Oversight by the IGIS and the committee would enable the implementation of a consistent best practice approach for the managing proportionality, propriety and governance across our intelligence functions. In this complex operating environment, the department welcomes the specialist and expert intelligence oversight the committee and the IGIS will bring. The department leads policy, program, delivery and operations to safeguard Australia's interests and contributes to a prosperous, secure and united Australia. This includes delivering policy leadership and coordination in national security, cyber and infrastructure security, and migration, citizenship and humanitarian and settlement programs. The Australian Border Force within the department protects Australia's border by facilitating legitimate trade and travel and detecting, deterring and responding to civil maritime threats. The department joined the national intelligence community following the 2017 Independent Intelligence Review. It's one of 10 agencies contributing to Australia's security and playing a key role in our national security architecture. The department is fully integrated within the national intelligence community's governance frameworks. It contributes to national intelligence to deliver effective operational outcomes and sound policy and strategy which underpin the department's efforts to provide a prosperous, secure and united Australia. However, the department is different from other members of the national intelligence community in that as a Department of State, our functions are defined in the Administrative Arrangements Order. When the department appeared before the former committee for the previous Intelligence Services Legislation Amendment Bill 2023, it was proposed that oversight would be limited to the functions performed by the department's then Intelligence Division. Since then, the department's intelligence division has been structurally realigned to a distributed intelligence model across the department and the Australian Border Force. As such, there's no longer an intelligence division whose functions as a structural entity can be the subject of oversight. Therefore, a new functional definition that captures those dispersed functions is required. This realignment provided efficiencies for the department's intelligence functions in supporting both the Australian Border Force's operations and immigration groups' intelligence requirements. The Department's intelligence function definition is to be provided for in regulations enacted by the IGES Act for the purposes of additional flexibility and to ensure that regulations are able to be adapted in line with any structural departmental changes. The regulations are yet to be drafted, and this process will be managed by the Attorney General's Department, and we've been working closely with the Attorney General's Department on these matters. It'll be necessary for the definition to provide a clear distinction between the Department's intelligence and law enforcement functions. The law enforcement functions are conducted under statutory powers such as the Customs Act 1901 and the Migration Act 1958 and are subject to existing oversight arrangements. The Department is already subject to robust oversight arrangements for all of its functions to ensure the Department's activities are operating in line with community expectations. And this includes oversight by the Commonwealth Ombudsman, National Anti-Corruption Commission, the Auditor General, the Australian National Audit Office, Australian Human Rights Commission, Office of the Australian Information Commissioner, Australian Public Service Commission, Public Joint Committee on Law Enforcement, and Parliamentary Procedure in addition to public disclosure through courts, administrative tribunals, privacy and freedom of information legislation. I might leave it there in the interest of time. Thanks again for the opportunity to appear, and we're happy to answer any questions.
Thanks a lot. Okay, now, Senator Cash, I'll hand the call over to you first.
Thank you very much, Chair, and thank you all for those opening statements. Could I just go to briefly the definition of intelligence functions, just to expand on that further? Can I just get how precisely does the bill in its current form define intelligence functions for agencies like the AFP, AUSTRAC, ACIC and Home Affairs? But more specifically, how will the definition avoid jurisdictional creep or gaps in oversight?
Thank you, Senator. I might take that in the first instance. So how it is approached is differently for each agency and really focuses on hooking into their statutory functions. So it directly links in and says when the agency is performing these functions, these ones are their intelligence functions. I might pass to my AFP colleagues in a second to explain how that is done in relation to them. But on your overlap question, one of the other key measures of the bill is ensuring there's appropriate information sharing between the Ombudsman and the IGES to make sure that there is sort of no gaps there. If the IGES is looking at something and then it sort of crosses that threshold into not being an intelligence function, they can engage with the Ombudsman to make sure there's a proper handover there.
Who makes that call?
Well, really, it's a matter for the respective oversight agency to determine whether it's in their jurisdiction or not.
Yep.
I don't know, AFP, did you want to talk about how the division between law enforcement functions and intelligence functions as an example?
Yeah, thank you. Thank you, Senator, for the question. Certainly the bill does define our exclusion for evidentiary purposes. Obviously, we do have a collection which ultimately will lead to a court process by which we are leading evidence. Not all intelligence does become evidence.
Yes.
And that's where we are working. So we have internally a working group that will engage with the Office of the IGES to make sure that where we are having conflict around what the definitions may be, that we are dealing with them at the time that we're identifying where there might be some discrepancies or ambiguities around the definition, to ensure that when we are fully rolling it out, there's a really clear narrative around what the definitions are and what our intelligence collected for evidential purposes, as opposed to, and going to the points, the intelligence that we collect in support of the broader NIC community and some of the strategic intent of the government, what that means and how we meet the obligations within that framework.
So if you had a matter that crosses, say, both intelligence and then non-intelligence functions, who actually then looks at that?
So we will be looking at that internally, and we will be working really closely with both Department of Home Affairs, with the Attorney General's Department, but also with the Office of both the Ombudsman and the IGES to ensure we know very clearly who has responsibility for that. And obviously the courts are the ultimate decision maker of any intelligence used for evidence purposes.
Senator, can I sort of say there too, so the IGES and the Ombudsman are working together at the moment in advance of this to develop a bit of an MOU to help them manage that handover. Really, one of the central purposes of this bill is actually looking at where the increased engagement between all of the 10 agencies and making sure that IGIS can follow the intelligence function to all of its corners. Now, when we have agencies that are doing both intelligence and non-intelligence, that's where we arrive at the next boundary. So the purpose was to make sure that we've got a specialised intelligence oversight agency that can follow intelligence to all of its boundaries, and then it's just going to be a practical matter for IGIS and the Ombudsman, supported by that MOU, to consider what is within their jurisdiction, and we've made sure that they've got that ability to hand over things when they figure it out that it actually doesn't lie on their side of the fence.
And thank you for that. So ultimately, it will be a matter either for the IGIS or for the Ombudsman. You wouldn't have something that was being looked at by both.
I think it is unlikely. There will be aspects that they will focus on. There is an option that for them to sort of work together and collaborate on something if it does cross both. But generally, I think they will specialise within their respective lanes, but we've made sure that there's no ability for there to be gaps, that they kind of got that ability to engage together, share information, work together without sort of creating any gaps in the jurisdictions. And
just in terms of the MOU that's been referred to, what is the exact status of it, and when will it be finalised?
Well, really, it's dependent on the jurisdiction changing. So it's only necessitated by the bill. So if the bill passes, now, this bill and its predecessor have been around for some time, so preliminary work has been undertaken, but obviously it will be finalised if the bill becomes law. There is also some transitional arrangements in place, to be put in place by the bill to allow where Ombudsman used to have jurisdiction and no longer does, to make sure that they can still pass any information over to the IGIS that becomes relevant there. So there's those transitional arrangements to manage the transfer of jurisdiction, but the MOU will be finalised to align with commencement if Parliament passes.
Just in terms of the oversight of the Department of Home Affairs by the IGIS, who will determine where that oversight begins and where that oversight ends?
So in relation to that, it's similar to the AFP's example, for the specific intelligence functions that are in the Department of Home Affairs, that'll be defined under regulations in the first instance. And similarly, we're trying to take care, as I mentioned in my opening statement, to distinguish between what is a law enforcement function and what is an intelligence function, and what is a general function for information that we provide for visa decision making, for example. And then the IGIS will have an opportunity to be able to review exactly what that looks like when we're working with the Attorney General's Department in relation to how we define all of those different components.
Just then, in terms of, say, decisions coming out of the Minister for Home Affairs, would they be subject to IGIS oversight?
I would struggle to see them as the performance of an intelligence function. I don't want to presume the outcome of how the regulations are formed. But it might be helpful to talk about some of the things that you consider to be intelligence functions that would just to give a bit of colour to what it would look like.
That makes sense. I might pass to my colleagues in Immigration Group and ABF to give some examples of what might be potentially captured by regulations, or a description of some of the functions of what we do that we're considering.
Yeah, and I'll run through those on the immigration side. Before running through them, there's nothing that comes to mind in terms of like a decision of the minister that would be intel. That the intel functions are functions that we as the department are performing that may, in certain instances, support decisions that the minister may make, but the decisions themselves wouldn't be an intelligence function.
So on the immigration
side, our intelligence function is really there to provide insights and make predictions about threats to the migration program and to certain aspects of Australia's national interests. I'll just break it down for you, Senator, really quickly, kind of the sorts of action things that we do. So we administer the Border Watch function, which is the department's kind of front door for the public to make allegations. And we, on average, at the moment, there's roughly about 1,000 allegations a week that are received through the Border Watch kind of portal. They can come from the community, they can come from industry, and typically they will be flagging either suspicious immigration or customs and border related matters. Those are kind of ingested. There's a triaging process. An analyst will look at that, and then it's referred to the relevant area in the department for appropriate action. We provide intelligence support to operational activities, and these are the sort of the immigration compliance operational activities. So that could be supporting the ABF out in the field in, for example, certain operations, looking at certain cohorts, UNC, unlawful non-citizen, that sort of thing, but also where there is an operation related to, for example, migrant worker exploitation. So feeding in, helping the ABF with sort of the targeting of where and when to go to engage in the immigration compliance functions. We provide intelligence to inform visa decisions, particularly around complex character provisions. So these are things like where they're an applicant, a visa applicant or visa holder may be flagged as having participated in a serious atrocity crime.
Yes.
So we conduct sort of some intelligence analysis to assist with informing the decision maker in that. Also, unwanted risk of critical technology transfer. So where we're seeing kind of a high risk of that, we have a team that does that work. And then I guess finally, I'd say on the immigration side, we provide a liaison point between our immigration functions and the rest of the national intelligence community. Some of that will be being the go-between between when ASIO is doing its work around security assessments on certain non-citizens, and then there is also other work where we liaise with parts of the intelligence community that that want to engage with border and immigration clearance processes to advance kind of Australia's interests through the things that they do, and we provide that facilitation to assist them in achieving that outcome.
Can I just, and thank you for that explanation, but just in terms of the question of whether or not ministerial decisions from the Minister for Home Affairs would be subject to the IGES oversight, the evidence so far has been that the regulations are still to be made, obviously. The regulations, therefore, are at large, and being regulations, they can change from time to time. Does the bill then currently, as drafted, leave open the possibility that ministerial decision could be subject to IGES oversight?
Actually, Senator, I might just jump in there. Sorry, I should have thought about this earlier. We've just been reminded of there is a provision in the existing IGES Act, which says the Inspector General must not, in the performance of his or her functions, inquire into action taken by a minister except to the extent necessary to perform the functions of the IGES in reviewing those performance of those intelligence functions.
Is that anticipated to change at all? Could it change by way of a regulation?
Well, that provision says you can't look at can't look at the actions of it taken by a minister except for those things.
Yep.
So
arguably
that is possible if in defining the intelligence functions you include the actions taken of a minister as an intelligence function, but I don't think at the moment we can conceive of any actions taken by the minister that would be appropriately regarded as an intelligence function.
No, and that answers my question, so that's fine. Just going back to, and I just want to make sure I've got this right in my mind, if IGES is unsure of its oversight responsibilities over a particular agency or the Department of Home Affairs, where does it actually go to seek advice?
Well, I mean, it's really a question of legal interpretation. So they could seek legal advice from the Australian Government solicitor. At the moment, the current IGES is a former federal court judge, so is, has a strong sense of legal interpretation himself there. There is also the ability for the Ombudsman and the IGES to work together to sort of ensure that their respective interpretations are aligned.
Okay. I'm sorry, want to keep pursuing the ministerial decision investigation possibility. So the IGES could investigate a ministerial decision if necessary based on the current Act, if necessary to perform the IGES's functions.
That's right.
Yep, thank you. I just wanted to confirm that. Thank you. Just going back to as well the duplication, is the government confident that the bill will not lead to duplication, inconsistency, confusion or oversight gaps in terms of oversight? And what safeguards have been put in place?
Yes, I would say that we are confident that we will not create gaps, and a big sort of pillar of that confidence comes from that information sharing I was talking about earlier. We've consulted thoroughly with the Ombudsman and the IGES to make sure that we are transferring jurisdiction in an orderly way, and that there are safeguards in place to ensure that they can cooperate appropriately with each other, to the extent that they have to sort of interact in exercising their respective jurisdiction.
Can I now go back to, and it was mentioned appropriately, obviously, the historical context of where we are today. And just going back to the 2019 comprehensive review of the legal framework of the National Intelligence Committee, which we all know as the Richardson Review. One of the recommendations coming out of the Richardson Review, as you'd recall, was that IGES should not have oversight of the Department of Home Affairs or the AFP, and that was recommendation 168. It made the following statements in particular about IGES having more oversight of Home Affairs than the AFP, and I'll just read it in so we've got it for the Hansard record. The IGES does not have oversight of any Department of State. Also, the intelligence function in Home Affairs is not encapsulated in a semi-autonomous agency such as DIO. Rather, it's simply another division in a wider department. Home Affairs has existing and effective oversight mechanisms for a Department of State. We question the value of adding more oversight. The AFP is a law enforcement agency, not an intelligence agency. To the extent that the AFP engages in intelligence collection activities, it does so in support of its policing functions. Its intelligence functions is integrated across the organisation rather than being a standalone unit. Extending the IGES oversight to the AFP's intelligence functions would be challenging to say the least, given the dispersed nature of that function across the organisation. So just in terms of the bill that we currently have, how's the government going to ensure that these concerns are addressed properly in the legislation?
I think if I could start first on Home Affairs,
yep.
And to sort of why is it being included now?
Yep.
I think, as Mr Burke highlighted, there is a clear and distinct intelligence function being undertaken in Home Affairs, and
yep.
that has grown over the years and is sort of continuing to grow. So it is clear there is an intelligence function being performed akin to other National Intelligence Community agencies. So that really goes to the importance of it. In terms of the challenge around defining that in a Department of State, that is the exact reason why we are doing that through regulations, to ensure that it has the ability to be flexible as functions change. Those regulations require. They can permit notification requirements as well, and the idea there is that should there be a change to those functions, there would be an obligation on the Minister for Home Affairs to notify the Attorney General or the IGES of a change in functions.
Just on that, can you just explain that just in more detail? Permit notification functions. Yeah, I'm just interested in that now that you've...
Yeah, I'll just try to pull up that provision for you. It is the regulations that permit the intelligence functions for the Department of Home Affairs to be defined in regulations. The regulations may also provide for the following in relation to changes to the intelligence functions of the Department of Home Affairs: consultation requirements and notification requirements. So the intention is that we can, through those regulations, have an obligation that says these intelligence functions are set in the regulations. If there is a change to those, or if something is materially different, notify either the IGES or the Attorney General's Department or the Attorney General, or however it is framed, to ensure that we can capture change. So we become aware of it at the time and can adapt the regulations quickly to ensure that it continues to appropriately capture what is the intelligence functions.
Which goes to, I think, what you said in terms of the historical context and where we've come from to where we are today in 2025, looking forward. Intelligence functions have grown over time.
Absolutely. I think everyone would agree that at the time that Dennis Richardson was reviewing the Department of Home Affairs, it's quite a different department in many senses now.
Okay, that's thank you. Just going back to as well, just again, given that I'm probably more familiar, obviously, because we were in government at the time, with the Richardson review, and obviously we had accepted the recommendation that the IGES should not have oversight back then of the Department of Home Affairs or the AFP. Just in terms of then the reasons given in the Richardson review at the time, and I think you're going to that now, but why also the government has now chosen to depart from that recommendation?
In relation to the Department of Home Affairs?
Or the AFP,
Look, as I said before, it is really just recognising the current state of the intelligence functions in Home Affairs as being akin to intelligence functions performed by other parts of the national intelligence community. There is that increased collaboration between the NIC agencies on those functions, and really just ensuring that we have specialised intelligence oversight capability and that they are being sort of deployed to look at like-for-like functions.
Okay. And just in terms of the fluidity of regulation making, which is why things are put into regulation, obviously, as opposed to legislation. Is the government confident whether the oversight arrangements in the bill are appropriate and, for want of a better term, are future-proofed?
Yes, I think the regulations for the Department of Home Affairs is a perfect example of the future-proofing. We all know that MOGs and changes to the AAO can happen quite quickly, and these regulations give us that flexibility. For the other agencies, the intelligence functions hook into their statutory functions, so to change those functions is going to require an act of Parliament, and therefore would give us an opportunity to make a consequential change here. So to change the functions of AUSTRAC, AFP, any of the other agencies' statutory functions, a bill's going to have to go into Parliament, and we'll attach a consequential change here to move together. It is those functions can't change without an act of Parliament.
Act of Parliament.
Department of Home Affairs is unique in that having their no statutory functions, their functions created through the administrative arrangement order.
Okay. Just in terms of how has the government considered the increasing prevalence of open source collection activities across areas of government outside the national intelligence community and the potential amplifying effect of what we're all becoming very used to, AI?
Look, it's an interesting issue and something the government is certainly looking at. There are lots of different agencies across the Commonwealth who are engaging in what could be colloquially referred to as intelligence functions to support their business. Really what we're talking about here, and we talk about intelligence functions, but we're more at that sort of national security end of intelligence functions, because that's where the expertise sits with the IGES. They are not an expert at the intelligence functions performed by the ATO or agriculture or anything else that may support smart decision-making in those agencies. This is a specialised capability that understands the collaboration between those agencies, the environments they operate in, and particularly the security classified nature of that. Having an oversight body that has staff cleared to be able to look at that is a specialist capability. So this is really about ensuring that that pocket of the Commonwealth that's working together on these national security intelligence matters has that dedicated oversight. But not to say that there aren't other departments, agencies out there doing intelligence. It's just not of the same nature require this specialised. And the Ombudsman does have oversight of those and is very capable at looking at that as well. But they don't require the same level of security clearances and things to unpack those intelligence functions.
Just in terms of the bill exempts certain defence authorised computer operations from liability, what safeguards exist to prevent abuse of this immunity, especially in cyber operations outside of Australia? Yeah,
so look, this is a somewhat standalone measure there. So if I could go to first the actual scope of the immunity. So this is about when people are undertaking sort of preparations or starting the activities to have an effect outside of Australia.
Yeah.
So it's about the onshore activities to do something that you reasonably believe will be outside of Australia. Yep. So there are other immunities that apply to people offshore doing things offshore. So the safeguards here are really around that requirement for them to reasonably believe that the effects will be realised offshore.
Offshore, yep.
Where there is, where they get that wrong, where there is a mistake there is a notification requirement. If they become aware that there was an effect onshore, they have to notify the CDF to ensure that there's appropriate level of awareness of that. They can do an internal review. They can decide what remedial action is required there.
Now, I understand. Yep. From a previous role, I do understand that now, yes. Just in terms of, again, the new oversight arrangements, etc., what measures are in place to ensure oversight does not unduly slow down or obstruct urgent intelligence operations while still at the same time being effective as an oversight mechanism?
I guess the difference between oversight, the key feature of it is not approval. The agencies have their legal frameworks they operate in. The IGES's role is to ensure that they're operating with legality, propriety and consistent with human rights. So it's not in any way slowing them down. The IGES, for particularly sensitive matters, may sort of observe in real time. They may sort of be there and be present when a power is being exercised.
And that's the current situation in any event, yes?
That's the current situation.
And it doesn't change under the bill going forward?
That doesn't change. So it's really the agencies have their legal frameworks they operate in to perform their functions lawfully. They are, depends on what the function is. There is expedited pathways to obtain ministerial authorisations or other various warrants and things. Oversight is really about ensuring that that is being checked and that there is sort of someone making sure that when an authorisation is given, that what is done under that authorisation is in line with it. And, you know, one of the special features of the IGES is not so much just that you're complying with the black letter of the law, but whether you're also, it's a proper, like they assess for propriety. So legality and propriety is sort of a key feature of their oversight. So shouldn't in any way slow anyone down, just make sure that what they're doing is appropriate, legal and proper.
So there's no actual change in terms of, if this bill was to pass, the current functions in terms of an oversight mechanism versus...
No, Senator.
Yeah. Just in terms of, this is an expanded mandate, if the bill goes through, what resource and commitments, staffing, budget, technical expertise, etc., have been made to ensure that the oversight agencies, for want of a better term, because I know they do their job incredibly well, but are not overwhelmed by the expanded mandate, and they're actually just to continue as business as usual?
So additional funding was provided to the IGES to ensure that they had the resources appropriate to expand their mandate.
So in anticipation of this particular piece of legislation going through?
Yeah, so in the 2023-24 budget, $12.2 million over 3 years from 24-25 was given to the Office of the IGES, with $4.49 million ongoing, and that was to expand the increased jurisdiction there. Also want to recognise something we haven't touched on is the expanded remit of this committee as well, and additional resources in that same budget were provided to this committee to support expanded secretariat given the increased functions. So that was $1.3 million over 4 years from 23-24 with $0.3 million ongoing, which equates to about 2 additional ASL.
Thank you very much. Just in terms of the expanded mandate of the Independent National Security Legislation Monitor, does that expanded mandate then allow it to review all national security and counter-terrorism legislation, or will there still be the carve-outs if required?
So the most recent independent intelligence review looked at this and recommended that the INSLM's mandate be expanded to all national security and counterterrorism legislation. So as to be sort of undefined and commonly understood. So what we've changed in this bill, and is a new aspect of this bill compared to the former bill, is to, at the moment, that is a prescriptive definition in the INSLM Act.
So what did you say it's a?
It's prescriptive. It says in national security and counterterrorism legislation is, and then lists a series of acts or parts of acts. What it's saying now is that the INSLM can look at any national security or counterterrorism legislation and then provides a non-exhaustive list, just making clear of some of the things that should be included in that term. One of the key aspects that the Independent Intelligence Review called out was some of the constituting legislation for intelligence agencies. So we made sure that in addition to all of the existing list, that those core acts are also added, but that is a non-exhaustive list.
Thank you for that. If oversight bodies identify misconduct or unlawful behaviour, what enforcement mechanisms exist to ensure that agencies or officials are held accountable? So
the primary, I suppose I'd say, output of the IGES is reports to government, reports to responsible ministers, to bring that to their attention, for then those ministers to be able to appropriately address that.
And that doesn't change again. There's no change in this legislation. It is the current status quo that has been.
The consequences available to the IGES currently are the same consequences here.
And just going back to if and when the bill passes, just confirming how the government will manage transitional issues to prevent oversight gaps or confusion whilst agencies do adjust to new obligations under the bill?
Yeah, so there's a period there. I talked about the sort of enduring information sharing arrangements between the Ombudsman and the IGIS, but there is the bill allows for some transitional arrangements as well, where the Ombudsman held information related to an intelligence function because they used to look after that to ensure that they can still share that with the IGIS. So those transitional arrangements are in there to make sure that there is no gaps created and there's an orderly transition of jurisdiction.
Okay. Just in terms of the Department of Home Affairs, how many layers of oversight does the Department of Home Affairs currently respond to? And the same question then for the AFP as well. And then after the bill goes through, how many layers of oversight will they then respond to?
So I ran through the relatively exhaustive list of things that we're currently under oversight for. I'm happy to go through some of those.
Would you mind? Yeah, and then just after the bill, is it expanded, etc.?
So a range of our functions are covered comprehensively by the Commonwealth Ombudsman, the National Anti-Corruption Commission, the Auditor General and Australian National Audit Office, Australian Human Rights Commission, Office of the Australian Information Commissioner, Australian Public Service Commission, Parliamentary Joint Committee on Law Enforcement, and then parliamentary procedure, in addition to public disclosure through courts, the administrative tribunals, privacy and freedom of information legislation. The only addition would be then we'd also be subject to IGIS oversight just for the intelligence.
So so it's the one additional there. So IGIS oversight, but in relation to, excuse me, the intelligence functions.
Correct.
Okay, and that's both for the AFP and for Home Affairs.
And so I just, sorry to butt in there, I just sort of say there too, it's not an additional layer, it's replacing. So it's displacing the Ombudsman oversight with IGIS oversight. So for part of the agency is still doing that. So it's not a new body to interact with, but not an additional body in relation to those functions. But sorry, AFP.
No. Thank you for that. That's appreciate the clarification.
Senator, I'd just clarify as well. We are currently subject to IGIS oversight with the use of our network activity warrants, in addition to all the other oversight. So on the same oversight regime as Home Affairs listed.
Yes.
And we are also subject to IGIS oversight with our network activity warrant activities.
Okay. The 2024 Intelligence Review took as a starting point that the predecessor to this bill, the Intelligence Services Legislation Amendment Bill, would pass, but expressly acknowledged the weight of the criticisms in the Richardson Review, which we've referred to. It said that those challenges could be overcome with communication. What additional communication will you put in place to actually respond to that?
Sorry, Senator, when you say communication, do you know what communicate, like between...
Between the agencies, etc.
So I'm not super familiar with the context of that quote, but I mean, one of the fundamental justifications for this bill is the increased communication between the National Intelligence Community agencies. So they are working more closely than ever together, and that is why we need this sort of the oversight to match that. And then, I won't go into it too much more because I've spoken on a number of occasions. The ability to allow for information sharing between the Ombudsman and the IGIS allows that communication at the oversight level
under
as well.
The MOU.
Well, no. So legally, to ensure that they can share that information, so that the bill does that. But the MOU is more the practical implementation of that.
Okay. Just in terms of any particular review of the effectiveness of this bill, has the government committed to actually evaluating the effectiveness of this bill as recommended by the 2024 review?
Well, I guess the bill hasn't passed yet to commit to the review, but look, I will swiftly correct the record, but I believe that recommendation was agreed to, that IR recommendation, which said next IR should review this. I believe
that's
that was
fine,
agreed
because
to.
you can take it on notice.
I'm very confident it did. Yeah,
that's fine. At this point in time, Chair, I do understand you've been incredibly generous in terms of allowing me to ask my questions, and I very much appreciate that. I'm happy to review my questions to see if there's anything I should place on notice, but more than happy now to hand back. And thank you very much to the officers.
That's right, I'm mindful of the time. Now, I understand, Ms Lawrence, you might have one question.
Yes, thank you. Schedule 3 of the bill gives defence officials broad immunity from civil and criminal liability for computer-related activities in support of ADF operations overseas. So the Senator Cash has spoke to that a little bit, but I just want to understand further, by contrast with ASD, ACES and AGO staff, why is there no requirement in Schedule 3 for Defence to report material damage or any harm to the Inspector General?
So why... Can you just repeat the last bit of your question?
Yeah, sorry. Why is there no requirement in Schedule 3 for Defence to report material damage or harm or interference of substance to the Inspector General?
So the IGIS's jurisdiction does not extend to the ADF or defence officials generally. They do have oversight of parts of defence, but not defence more broadly. So that's why there is a mechanism there to ensure it is reported to either the Secretary of Defence or the Chief of the Defence Force.
So was any consideration given to conferring a role of that nature to the Inspector General? I mean, just for where there's material damage or interference to an external oversight body, was there, who will be monitoring that then?
Yeah, the challenge is I just wouldn't be the appropriate body there because they do not have that that foundational oversight of the ADF. There are other oversight arrangements in place for the IDF that are more appropriate to receive that notification and respond to it. A notification to the IGIS, because it doesn't have broader jurisdiction, they wouldn't then have the powers to then inquire into the matter. So it's best placed within the broader defence oversight arrangements, including the Inspector General of the ADF.
Thank you. Thanks, Chair.
Thanks a lot. Now, I just had a question in relation to the vetting requirements for the wonderful staff, the secretariats. Can you just explain maybe the substance of the change that's been proposed in the bill?
Yeah, thank you, Chair. So currently under the Intelligence Services Act, it provides that each member of the staff of the committee must be cleared for security purposes to the same level and at the same frequency as staff members of ACES. What is changing in the bill is to replace that clause with a requirement that each member of staff of the committee must be cleared at a level and frequency appropriate for access to information and systems at the classification that the staff member requires, in accordance with the government's protective security policy and acceptable to all of the agency heads.
So the origin of this amendment, like what's provoked us from doing this?
So this request came from the Secretariat itself, and as I understand it, and I don't want to sort of verbal them, but as I understand it, is the ongoing resource challenges around obtaining appropriately cleared staff, particularly noting with the way that the role of this committee has expanded over time is quite different to when it was first instated. So now there is more public hearings. It is looking at a lot of legislation, not just sort of expenditure and review through private hearings of intelligence agencies. So the hearing we are in currently obviously does not require someone to have a clearance akin to an ACES staff member. So what this arrangement would permit is a multi-classification workforce within the committee to give them respond to the workload and meet the workforce challenges, while still ensuring that no one accesses information that they're not cleared to access.
Can I ask a follow-up, Chair? Because I'm very interested in the question that you've just asked. Given the nature of, look, we all understand the nature of the work of the committee, intelligence, etc., security, it's just got to be, no two ways about it. You said if agreed by all the department heads. Does that mean I no longer need the ASIS level security because that's not my role? Do all of you have to agree that my security requirements can now be downgraded?
So I think that's something that we would expect the committee to work through with the agency heads. I would expect that would not be done on an individual person basis, but more of a standing arrangement to confirm comfort there, rather than one particular employee moves out and that all agency heads have to sign on that particular new staff member. I think it is a broader standing arrangement could be come to, where we say that the audiovisual staff for public hearings, all agency heads are happy that they do not require a clearance beyond an appropriate level, except if that's a private hearing where this will be discussed. And so there could be a standing agreement around those arrangements.
Okay, okay.
Does it tied to the role rather than...
Yeah, okay. Sorry, Chair, I jumped in.
I mean, the fundamental piece, though... Oh, sorry, Chair.
Are we discussing about the type of role that the individual performs rather than the individual themselves? Like, you know, if you're the secretary, for instance, you'd have the highest classification versus one of the other admin staff, for instance.
Yeah, look, that is what I think would be the most appropriate way to approach this. Ultimately, it will be a matter for the secretary and the secretariat and the agency heads to settle on. But the fundamental kind of premise is actually in the paragraph before that, the agency head bits, which is ensures that no one will access information that they're not cleared to access. So there is still that arrangement there.
Chair, can I jump in there if you're finished? I'm just wondering. I'm assuming that the gentleman talking is James Morrison. Is that right?
No, Luke Muffet.
That's Luke. Okay, sorry.
Wrong assumption.
Sorry, Deputy Chair.
I don't have access to your name tags when we're calling in. So, Luke, just on that, can you tell us what consultations you've had with the Secretariat on this issue? My concern is, whilst I understand the rationale, I'm just not sure that the housing of the Secretariat's office is going to be conducive to what you're trying to achieve.
So, look, this consultation was undertaken. I don't have the date in my mind, I apologise, but it was in the formulation of the predecessor bill, the Intelligence Services Legislation Amendment Bill. So in early 2023, I would say, in preparation for that. We were requested by the former Attorney General's office to consult the Secretariat to understand whether there were any procedural improvements that would be beneficial to consider as part of the bill. This was one that was raised with us. We've attempted to implement that in line with how we understand that to work. We were very conscious, though, that this bill is going to be considered by the committee that is amending it. So I very much defer to you, to the Secretary, in considering that to figure out how it works, because I, as an outsider, do not know the internal administrative arrangements that go on with the Secretariat. This is our attempt to implement the spirit of that request, but would certainly welcome any suggestions on how to improve that from the people who it's directly affecting.
And it's a very small office that they work within, and there's not a lot of, without going in too much detail, I just have some concerns, and perhaps that's something that we can we can discuss with the Secretariat Chair about how this would physically work, noting that Luke's evidence is that it was the Secretariat's suggestion. So we might be able to take that to the Secretariat themselves. But we can park that for the time being. Chair, I've just got one pretty quick question.
Yeah, before you do that, I just wanted to ask one last thing following on from this conversation, and just to be clear. So, has either department received any feedback then from the NIC about the amendment, and are there any concerns?
We consulted them on the entirety of the bill, including this aspect, and that they are comfortable with the bill as it stands. Ultimately, if it is a small office and there is not an ability to create separate roles, nothing is required to change. Everyone can still be cleared to the highest level. This is about ensuring flexibility in the way the committee goes about it. But to your point, Chair, no concerns raised, particularly noting the requirement for it to be acceptable to all agency heads. They are comfortable, they accept it. Many of those agencies are also considering multi-classification workforces themselves as they face the challenge of obtaining and retaining cleared staff.
And just one last thing from my end too, with respect to cleared staff, have there been any thought come across your department or others in the NIC around the chair of the committee or the deputy chair of the committee being able to have at least a staff member that's cleared to help them assist with the work they do on the committee, given the expanded remit of this committee now going forward?
Unfortunately, Chair, that's a bit outside of our remit in determining this bill, and that sort of assignment of staff is really a matter for the Prime Minister and the Prime Minister's department.
In terms of staff being able to assist the chair, not saying additional staff, I'm just talking about existing staff, but at least having someone that's either cleared or nominated to be cleared to assist the chair.
Oh, look, that would really be. I'm sorry. It's because of how they're engaged. It's not really one for us. But
that's okay. All right. Thanks, Andrew. You've got the call, and then we'll wrap it up.
Thanks, Chair. Luke, I think it was you that said that very early on in your evidence, and it may have not been, but consultations with many agencies include the Department of Infrastructure. Was that you that said that?
Sorry, I think that was me, Sarah Samios. Yeah.
Yeah. Okay. So, can you just outline why the Department of Infrastructure was consulted? Was it around critical infrastructure issues, and what the outcome of those consultations were specifically with Department of Infrastructure?
Thank you. Yeah, Mr. Muffet will take you through some detail there.
Thanks, Deputy Chair. Mr. Muffet again. Look, this is more just a technical requirement. As I understand it, there is parts of the Telecommunications Act that are administered by the Department of Infrastructure Communications, and I won't be able to recall the other titles in that department's name. So this was just around obtaining approval for the consequential amendments to the Telecommunications Act.
Okay. So just can you take us through what those consequential amendments are?
Yes, just one moment as I try to pull them up.
Did you have any other follow-up questions, Andrew? I'm mindful of time.
No.
Okay.
No.
So the changes there are around information sharing and who notices are to be given to. So it really this flows on from the ACIC, Australian Criminal Intelligence Commission, moving out of Ombudsman oversight into IGIS oversight, and is clear there that when they have to give notifications, they are now to give those to the IGIS, not the Ombudsman. But other agencies who are still under Ombudsman oversight continue to give their notifications to the IGIS. So it's just correcting reporting lines as a result of that transfer of jurisdiction.
Thanks for that. Thanks, Chair.
All right. Now, Senator Cash, I understand you've got one question.
One follow-up question. Just following up from the questions about security clearances, are there any other changes that the bill makes to PJ Sis's internal processes?
Two worth calling out. There's a provision that allows a bit of a modernisation of proceedings. I'm just going to try to find it for you around being able to really reflect the practical arrangements, such as conducting inquiries with remote people. So
public inquiries.
Inquiries remotely there. And there's also allows the ability to appoint subcommittees.
Yes, which we've done. Yep. Okay. Thank you very much. Thank you so much for indulgence, Chair.
Okay. No other questions from other members? Otherwise, can I just say thank you very much to all our witnesses for appearing today. If you've been asked to provide any additional information, please do so by 12 noon tomorrow, the 3rd of October. Now, you'll also be sent a copy of the transcript of your evidence and have an opportunity to request any corrections to if there are any errors within the transcript. There be no other witnesses.
Sorry, Chair. Could I just interrupt there? One of my diligent staff members back in the office who has been watching has also just corrected me. The engagement with communications was about Archives Act, which they administer, about the Archives Act, amendments to the Archives Act.
All right. And that was in relation to what question? Sorry.
That would be in relation to my question.
Okay.
Yeah, sorry, Deputy Chair.
Thank you. I just want to get that on the record. All right. Now, on that note, I now declare this public hearing closed. Thank you, everyone.
Thanks, Chair. Thanks, everyone.